Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson. Now, Judge Simpson is doing what he has labeled his JFS docket. For the life of me, I don't know what that means. In today's pre-show, we tried to figure it out. We couldn't. So, wisdom of the crowd, if you know what in the world a JFS docket is, let us know. Maybe we'll figure it out as we watch.
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Yes.
Well, and to that charge, how do you plead? Guilty?
Oh,
Not
guilty. Sorry.
How do you plead?
Guilty.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I
You
understand.
signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
No. Nope.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will
Yeah.
and because you believe that you are indeed guilty of this offense?
Yes.
June 9th, 2022, at the location of 7000 East Michigan Avenue, that being the Walmart. Were you an employee of Walmart?
Yes, I was.
All right. What'd you do that makes you think that you're guilty?
I was an employee of Walmart and I was ringing up gift cards.
You were
Ringing up gift cards.
okay. You were a cashier?
Yes.
All right.
I was a customer service representative.
Okay. And you were ringing up gift cards?
Yes.
Explain to me, what do you mean you're ringing up gift cards?
I were loading gift cards. Loading gift cards.
You were loading gift cards. And when you were loading these gift cards, was somebody giving you money to load onto those gift cards?
No.
All right. What was your intent to do with those gift cards then?
Purchase stuff for my child.
Okay. Fair enough. You were going to keep those gift cards and then use them to purchase items from the store.
Yes.
All right. And at no time regarding those gift cards did you supply the money that was the sort of the backing for those gift cards, correct?
Mm.
You came into possession of those gift cards as well as had the ability to load those gift cards by virtue of the fact that you were employed at Walmart. Is that correct? And nobody from Walmart gave you permission,
No.
correct?
Yes, that's correct.
And the amount in total that you loaded onto these gift cards, was that in excess of $200?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied. Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 9th, 2025, 9 a.m. Bond will pay.
Thank you, Your
Thank
Honor.
you.
What am I calling? Court calls the case of the people versus Elizabeth Wilson.
Ashalani for the people.
Michael Kelly, P77187, on behalf of Ms. Wilson, who's present standing to my right. State your name for the record, please.
Elizabeth Wilson.
Did I have her sworn already? Pardon? I did. All right. All right, you have been sworn. And ma'am, it's this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased times the value of the property by $500. That would become the maximum fine. Understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand is absolutely desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea?
The police report, Your Honor. That would be. Oh, I'm sorry. Oh, the base. Oh, concern for prospective civil liability, Your Honor. Caught me sleeping there. I was ready for it. I was ready for it. I thought you wanted me to give this exact number. I was like, okay, okay. Proceed.
Well, thank you. My court. Appreciate you giving me permission. Ma'am,
Yes,
to that charge, how do you plead?
no contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-16-502. Any objection to the court having reviewed that report?
No, Your Honor.
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Satisfied.
Satisfied, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report and determination of any restitution, and prosecutors deferred. Sentencing in this matter will be July 9th, 2025, 9 a.m.
Your Honor, can I get an alternate date on that? I'm supposed to be in Rochester at 8:30 that morning.
July 23rd at 9 a.m.
That works.
July 23rd, 2025, 9 a.m.
Thank you, Your Honor.
Bless you. Bond will continue.
Thank you.
Johnson and Mac and Drukas?
And Foster Tucker.
Really?
Not me.
Andy.
And Mr. Livingston. I kind of feel about that.
I really don't want to talk to any of them.
I know. We're gonna have a good time.
All right, let me.
We only need 5 minutes.
You always say that, and then it's a half an hour later, and I don't know what the heck is going on.
We actually are on the same page this morning.
What?
We're on the same page this morning.
Are you in the same book?
Yes, very close.
Probably right. I'll take them. Court is standing recess.
All right.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Friday to all of you. Let's go to Florida. Judge Mercer doing, I believe, first appearances.
Hi, good morning, Mr. Fortune. Chris and Brandy are in the courtroom on your behalf. I just want you to know they're here on your behalf this morning. You're here because you've been accused of missing a court date in Judge Garcia's felony court. She's issued a no bond warrant in your case, so you're going to be held with no bond until you can get over to circuit court and try to get this case resolved. Mr. Fortune, it was an arraignment date that you missed, so you'll be put on the next arraignment docket, and then you'll get attorney appointed at that point if you request one, if you qualify for one. But right now you have no bond. Mr. Fortune, do you have any questions?
No, sir.
Does the friends or family have any questions? You're good? All right. Wish you the best, sir. That should take us back to the top of the list, Mr. McDaniel, unless you need to take somebody out of order. Otherwise, it would be Kevin Hansford. Mr. Hansford, good morning. Mr. Hansford, you're here because you've been accused of one count of possession of drug paraphernalia. In addition to that, you have a no bond violation of conditional release warrant out of Calhoun County. So even though I'm going to set your bond in Jackson, be aware, excuse me, if you post a bond in Jackson County, you would go from our jail to theirs. You wouldn't be released onto the street because they do have a warrant for you. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Your Honor, I just spoke with Mr. Hansford and he changed his mind. He's going to go ahead and enter a plea of no contest. The charge is listed, 90 days in the county jail, 1 day jail credit, $370 fine, wages, right to a jury trial, and call witnesses.
385. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Hansford, it's 385 fine by state law on that particular charge if you're adjudicated guilty. Mr. Hansford, any questions about that plea agreement?
No, sir.
And is that the plea you would like to enter to resolve that misdemeanor case?
Yes, sir.
Mr. Hansford, I'm going to accept your plea of no contest to the charge of possession, drug paraphernalia. The judge will give that offense, sentence you to 90 days in jail, give you credit for the time you've served. Mr. McDaniel, is that 1 day?
Yes, Your Honor.
1 day credit, $385 court costs and fines. Mr. Hansford, there's no probation involved in this sentence. So when you finish the jail sentence, you'll be released. Now, a couple things could happen. If you're able to resolve the Calhoun County case, then good for you. You would maybe be able to resolve it while you're sitting here waiting it. That's rare. Usually that doesn't happen. But if you do, then you'll be released when you finish the 90 days. Otherwise, when you finish the 90 days or when you get close to the end of the 90 days, Jackson County will go ahead and take you down there or ask them to pick you up. Usually when someone gets down close to a week or so, somewhere around that area, Jackson County will go ahead and let you go down there. So you may actually do the last few days of this sentence in that jail. Mr. Hansford, do you have any questions?
No, sir.
All right, Mr. Hansford, wish you the best, sir.
Yes, sir.
Thank you. We have Deborah Richard. Ms. Richard, good morning. Ms. Richard, you're here because you've been accused of 1 count of grand theft between $750 and $5,000. Ma'am, I have read the complaint. I misread it the first time. I think when I sent the text out, Mr. McDaniel, and went back and on the second defendant and read it, I felt like I was a little clear on what the accusations were. Mr. McDaniel, do you want to be heard on probable cause at all?
Well, I assume that the correct charge would be principal to grand theft, not grand theft, but I don't have anything additional. I mean, I think the charge is wrong.
You agree with that, Mr. Mitchell?
We're in agreement.
So it's the same degree crime. I think that everybody agrees it should be principal to grand theft, which means that you allegedly aided and abetted or you are helped facilitate a crime. That's what you're charged with, Ms. Richard. That's what I'm finding probable cause for. Based upon your criminal history, you're probably not a conditional release candidate, ma'am, but I think you're entitled to a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Ms. Richard, I'm going to set you the standard bond I normally set for grand theft with some history, ma'am. Your bond's going to be $5,000 cash or surety. Cash or surety means you can go through a bondsman. You don't have to come up with all of it. You do have a condition, no contact with any Walmart while the case is pending. Ms. Richard, do you have any questions?
No, sir, but I know I didn't steal nothing.
Don't say anything.
Okay, yes, sir.
All right, ma'am. Wish you the best. Abdullah Al-Halal.
Your Honor, we did have somebody come in.
Are you here on that case, sir? And I want to tell him you're here, if you want to know your relationship. If I just say friend, he's not going to know who's here. Can I give him a name? Okay, Muhammad is here. That's probably a common name in some cultures. Muhammad Shahjahan is here on your behalf. I just want you to know he's here on your behalf, sir. You're here because you've been accused of selling or providing nicotine products, big difference, nicotine products to a person under 21 years of age. There is probable cause in the complaint. I'm going to appoint the public defender's officer to represent you and ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Abdullah. He's going to enter a plea of no contest. The charge is listed. Your understanding, he's going to pay a $370 fine within 60 days, or he'll serve 10 days in the county jail. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
And Mr. Mitchell, anything from the state?
No, Your Honor. That is agreeable with the state.
Mr. Al-Halal, did you hear that agreement, sir?
Yes, sir.
Do you have any questions about that agreement?
No.
And is this the plea that you would like to enter?
So is it?
Is this what you want to do? The plea that you're trying to put on the record, is that what you want to do?
Yeah, sir.
Okay. Mr. Al-Halal, The criminal history I've got shows no prior criminal history. Is that accurate?
No. You've never been in trouble before, have you?
No,
At least not in America, I mean.
Okay. It's first time.
All right. I'm going to accept your plea of no contest to that charge, withhold adjudication of guilt, sentence you to 10 days in jail, but you will never serve that 10 days as long as you pay the court costs and fines. They're set by state and county law at $370. They're due by August 6th. Mr. Al-Halal, if you get them paid by August 6th, the case is over. You do not come back to court. If you cannot get them paid for any reason, you need to be in court August 7th, 2025 at 9 a.m. in the county courtroom to ask for an extension. So if you get them paid, you don't come back to court. If you need an extension, you can come back to court. Lastly, Mr. Al-Halal, the offer's been made. It's just a fine because you have no prior history. If you're accused of this, if you're accused of this in the future, if you're convicted of it, that is, in the future, it would be a different sentence than a fine. So you need to realize this is a standard offer, a standard sentence for a first offense. But you're accused of, you need to.
It was my
mistake.
mistake.
You need to, if this is true, you need to tighten up on your process of who you sell nicotine products to. Now, do you have any questions, sir?
It was my mistake. By mistakenly, I was on a phone that time. Maybe I don't know who might sell. I was on phone. I was busy on phone. That's why maybe by mistakenly.
Yes, sir. It happens. And you may have a great system, and just maybe one time where you didn't follow it, but just make sure that I don't want to see you get to this charge. Okay. And Mr. Al-Halal, what's going to happen next? And talking to the gentleman in the courtroom also, he's going to be processed out. They're going to let him get dressed in his regular clothes, and he'll be released. That's probably going to be inside the next 30 minutes or so. Are you going to be able to pick him up? Yes. Your friend said he's going to be able to pick you up in just a little while. Any questions, sir?
Any questions?
No.
Mr. Al-Halal, do you have any questions?
No, sir.
In the courtroom, any questions, sir? No, sir. Wish you the best, sir. Hey, Mr. McDaniel, you want to give that? Mr. McDaniel, is it okay if we give the disposition to the gentleman in the courtroom?
Correct. That's Muhammad, isn't it? So yeah, that's fine. And if he wants to pay the payment, he probably can pay it there at the clerk's office.
It's up to you. He doesn't have to pay it today, but if you want to pay it while you're at the courthouse, you can do that, sir. All right, thank you. Yes, sir. We have Roger Thomas next. Mr. Thomas, good morning. Mr. Thomas, you're here for first appearance because you've been accused of one count of grand theft between $750 and less than $5,000. There is probable cause for that charge. Mr. Thomas, you also have holds out of homes in Washington County, and both of those are no bond holds. So even though I'm going to set you a bond in this case, because you're entitled to one, understand that if you post it, you won't be released to the public. You'll be transported to another jail. Mr. McDaniel, anything on his bond amount before I set it?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Thomas, your bond's going to be $10,000 cash or surety. The reason your bond is higher than Ms. Richards is because you have other charges pending, violation of probation charges, but your bond is $10,000 and you've got a condition, no contact with any Walmart while the case is pending. You have questions,
Yes,
sir?
Yes, sir.
Okay.
Yesterday, I got locked up. Ricky Rowlett got locked up, and Deborah Richards got locked up. They had nothing to do with none of that. It was all me. They didn't even have no. I didn't tell them what I was going to do. I told them I was going to buy something, and I swear that's what it was. They had nothing to do with none of that.
The problem is that according to the complaint, this is what the complaint says. The complaint says they put the items in a cart, push it down an aisle, and leave it there. You come get that cart and take it outside. That's why they're accused of principal, is according to the complaint, the video shows that. So that doesn't exactly fit with what you're saying when you say they had nothing to do with it. That's why they're charged. So you need to talk to an attorney before you say anything else, is my suggestion, okay? Have a good day. Ricky Rowlett.
You know what? 2609.
Mr. Rowlett, good morning. Mr. Rowlett, you're here for first appearance, also accused of grand theft between $750 and $5,000. There is probable cause It's a scenario it's the same complaint as Miss Richard and Mr. Thomas. Mr. Rolak, it was a little confusing when I looked at your criminal history. It appeared to me that you just got out of jail yesterday in another county. Is that accurate?
Yes, it was the day before I had resisting without violence.
Okay. And that was where? Washington or Holmes?
Yes, it was Washington.
Washington.
Okay. Let me see if the attorneys have any additional information before I set your bond in your case. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Rolak, your bond's going to be $7,500 cash or surety. The reason your bond is that amount is because you don't have any charges pending, but you did just get out of jail 2 days ago. That's obviously a factor for me to consider. And when I set a bond, you also have a condition of no contact with any Walmart while this case is pending. Mr. Rolak,
Yes,
you'll
sir.
get a chance to use the phone in just a few minutes, sir, to try to post the bond. Do you have any
Yes,
questions?
sir. No, sir.
All right, sir. Wish you the best.
Thank you.
Yes, sir. We have Michael Phipps. Mr. Phipps, good morning. Mr. Phipps, you're here because you have a hold out of Washington County. I pulled up the warrant this morning to see if there was a bond on it, and there's no bond. It's a violation of state probation allegation against you with no bond. So, Mr. Phipps, you'll be held for Washington County. Today's Friday. You may get over there today. It's possible. It's also possible it'll be sometime the first of next week. Any questions, Mr. Phipps?
No, sir.
Have a good day, sir.
Thank you.
Yes, sir. We've already seen Mr. Fulcher. That leaves us with Adriana Clemens. Ms. Clemens, good morning. You're here because you are charged with one count of organized scheme to defraud. Mr. Mitchell, that's not a charge. I see that often, so I looked at the statute. And the statute number is wrong with the complaint. It appears she's charged with 817.0344B1. That's talking about communicating with someone about planning a scheme to defraud. What I think he intended to charge her with is 817.0344A3, which is just regular old organized scheme to defraud. So there's probable cause for the charge. I just don't know that that's that subsection of that section of Florida statutes. I think it's the wrong subsection, but I'll ask Mr. Mitchell to notify the officer and see if that's what he or she intended to charge. Ms. Clemens, so there is probable cause, but the good news is what I'm showing is no prior criminal history at all. Ms. Clemens, is that accurate?
Yes, sir.
All right. Ms. Clemens, let me see if the attorneys have any additional information they want to make me aware of other than that. Mr. McDaniel?
Nothing else, Your Honor.
Mr. Mitchell?
No, Your Honor.
Ms. Clemens, I'm going to let you pick between a bond and a conditional release because your criminal history is perfect. It was perfect until yesterday. Ms. Clemens, you can choose the bond if you wish. The bond I set for third-degree felonies is almost always going to be $5,000 cash or surety. So I'm going to set your bond. Actually, this may be a case where it's more appropriate to set a cash bond. Mr. McDaniel, any objection to that?
I don't have any objection to that, yeah.
Mr.
money?
Mitchell?
No, no objection.
Well, she's not gonna be able to pay anything anyway, Your Honor, so.
Can you or your family post a $250 cash bond, Ms. Clemens?
250.
$250.
Yeah,
Just,
yeah.
you can do that?
Today. I can have my mom do it today.
Your mama do it? Okay.
Do I
I'm
get
gonna
mom?
let you pick between a conditional release and a $250 cash bond. Mr. McDaniel's probably gone over the conditional release with you already, but just let the jail know after first appearance which one you prefer. And I'm glad to grant you either one. Either way, you have a condition, no contact with any Walmart while the case is pending. So just talk to Mr. McDaniel about the difference, and you can let the jail know whether you want the conditional release or the $250 cash bond. The cash bond has fewer rules to follow. That's why some people prefer a cash bond. Ms. Clemens, do you have any questions you'd like to ask me?
No, sir.
All right, man. Wish you the best.
Let's head north. Let's go say good morning to Judge Meineke.
The Xanax in my system, I don't remember that day. That's why I was like asking him to go over the police report.
So would I'm trying to remember, would Xanax fall under the analogs?
It is a controlled substance, Your Honor. Yes, but she's been prescribed Xanax. It still doesn't mean she can take an inappropriate amount before driving.
Well, that's
But
well, count two though. I need that. So
So count 2 was the possession of the clonazepam.
I got it. That makes sense. So basically what I'll do then is instead of the use of, I'm going to take a plea as if it was the original charge, Mr. Bennett. Is it true that you were in possession of cocaine and you were in possession of Klonopin on February 29th, 2024 in the city of Royal Oak?
Yes.
Okay. And would you agree that, that through the combination of multiple substances, including cocaine, that your ability to operate that vehicle in a normal manner was substantially affected?
Yes.
Okay. I think I checked all the boxes there. Ms. Rosenau?
Yes, Your Honor. I'm satisfied.
Mr. Bennett?
I'm also satisfied, Your Honor. Thank you.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. Now, I do recognize that there are a host of controlled substances and why she would be an appropriate candidate for sobriety court. I'm going to refer her for an alcohol screening and assessment, a drug and alcohol screening assessment. And I think we will uncover, and it's very important, Ms. Albasari, that you were honest with all of the different controlled substance interactions that you have and experiences that you've had. So we understand the depth of the challenge that we're facing. I do want to reinforce to you, because there is plenty of information in the police report that suggests that you did have contact with whippets, inhalants, those types of things.
Mm-hmm.
We work very hard in our sobriety court, and through the work of the people in the program, the team, the court, our probation officers, we've been able to achieve a high level of success. Thank goodness. That being said, one of the most difficult substances that we have to work with when it comes to getting people away from it are any type of inhalants. That is, we've had more success getting people off of heroin, cocaine, even people who've had experience with fentanyl. We've had way more success. I just want to make sure that you understand the stakes of the game that we're playing, because when it comes to this particular substance, we're going to have to work every single day to keep you sober and keep you away from that.
Okay.
And so I'm willing to make that type of investment of the court's resources, time, and energy. Mr. Bennett has fought hard for you. The prosecutor believes that you are capable of long-term recovery.
Thank you.
But all of us,
Mm-hmm.
Mr. Bennett, Ms. Rosenau, this court, our entire sobriety court, we cannot make it happen. Only one person can make it happen. And that's if you decide, I need help, I need to continue to do this work every single day, then we can overcome just about anything together.
Mm-hmm.
So I just want to make sure you understand where we're at, where we start. What we're dealing with is very dangerous.
Yes.
Together with you committing to this, we can get it done.
Mm-hmm. And like I said, I'm more committed. I told them I've been like being sober, and I feel like this might like even affirm it. So I can, you know what I'm saying? Just the longer, the better. Being around the wrong people, I know sometimes I had to cut off like a lot of people in my life. You could slip up so quick. So I understand what you're saying. It is very hard sometimes, to fully like quit. But thanks to my doctor, I've been checking with my therapist, my psychiatric, my doctor. They're all been, with the help with the medications too. And with my children, I'm saying, like, just by being out doing more normal things, setting an example. And I always remind myself when I wake up in the morning, I'm setting an example, because one day they're becoming teenagers. I never want to see them in this position. So I'm not just doing this for myself. I'm doing this for me, my kids, and my parents, for everybody. And if it does help the community, the fact that I was in this position, and now coming, and I'm in my school right now, like I got back to school. So I'm trying to be on like a good, path of like bettering myself, my career and everything. And a little slip up will probably put me in a bad situation where everything's going to get thrown away,
Right.
Good job, Asma.
Yeah. Thank you. And I thank you so much again.
All right. So we'll review her for sobriety court. Mr. Bennett will be in touch with setting her up with an interview. Counts 1, 2, and 3 are dismissed on motion of the prosecutor. I've accepted the plea to the reduced charges of 2 counts of use of a controlled substance and 1 count of operating while visibly impaired. We'll see you back here for sentencing. Good luck, ma'am.
Thank you.
Thank you very much, Your Honor.
Bond is
Thank you,
continued.
Thank you, Ms. Ross. Now have a great day, everybody. Have a good weekend.
You as well.
Thank you.
Thank you.
Thanks. Bye.
Mr. Bennis,
Yes.
I'm gonna be reviewing the police report, okay? So you don't have to make any statements. Mr. Steinberg, I'm taking a look at Royal Oak Police Report number 25009742. Ms. Rosenbaum, do you stipulate to the use of that?
Yes, Your Honor.
And
Oh,
Mr.
yes,
Steinberg,
ma'am.
and Mr. Steinberg, yes. Okay, good. All right, give me 1 second. Let me get through this. Okay. All right. I'm satisfied that contained within the police report, there is a factual basis to establish that on or about April 1st, 2025, that Mr. Bennis did intentionally make a false report of the commission of a misdemeanor stalking to a peace officer of the Royal Oak Police Department, knowing that the report was false. Satisfied, Ms. Rosenau?
Satisfied, Your Honor. Thank you.
Satisfied, Mr. Steinberg?
Yes, sir.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. I need to find out a little bit more information about this situation and make sure that Mr. Bennis is in the best possible position to move forward from a very challenging event in his life. So my staff will be in touch with you, Mr. Steinberg and Mr. Bennis, to set up a probation interview, and then we'll set up the terms of probation, because I do believe Mr. Bennis will be a probation candidate rather than a jail candidate at this time.
Thank you, John.
Anything else, Mr. Steinberg?
Not on that. I just want to tell Mr. Bennis your return date will be in person with Judge Meineke.
Okay. Yeah. So, Mr. Bennis, the way it'll work from here is you'll get 2 dates. My staff will reach out to you and Mr. Steinberg. You'll get 2 dates. One date will be an interview with probation. Now that'll still be on Zoom, so you can have a conversation with my probation department. They're going to gather information. Mr. Bennis, all I know about you right now is what happened in this event. My guess is there's more to you than that. And so that's the whole goal, is to get a more comprehensive look before we come up with the terms of a sentence. Now, the actual day where you get sentenced, you will have to be in person. You'll be with me. You'll be with Mr. Steinberg, and we'll walk through what you'll need to do as far as a consequence. Got it?
Okay, thank you.
All right.
All right. Good luck, everyone. And Mr. Steinberg, do we have another case together?
Yeah, we have Mr. Herner, but I'd like to go.
Let's head north. Let's go to Judge Elmore up in Wexford County, Michigan.
All right, Mr. Sutton is being brought in. He's currently being held in pretrial custody. Told there's a resolution today. Thank you.
Yes, Your Honor. Today, Mr. Sutton will be pleading guilty as charged. All 3 counts in the complaint. He's pleading guilty with a plea and sentence agreement that he will serve 6 to 15 years on each of these charges, that those sentences will run concurrent to each other, and that the prosecutors or the Attorney General's office, prosecutor's office, will not pursue any additional charges that he confessed to at the time that he confessed to the 3 cases that are charged. 3 charges, excuse me. So in the case, he confessed to 3 counts of CSC third. He also confessed to some counts of CSC second. we are not going to charge those as part of this plea agreement.
I'm gonna ask here a question. The alleged offenses to which he made or a confession, were they involving the same defendant, that's the
Same victim, yeah, same victim, same
scenario?
transaction.
All right.
This all occurred over the course of a weekend that he was staying with this minor victim and her family.
All right, thank you. Mr. Cherry, is that a complete and accurate statement?
It is, Your Honor, and maybe just for the fullness of the record, that would be the 2015 confession.
That's when he confessed back in 2015?
Correct.
Or the, hold on.
The offenses occurred in 2014.
Okay.
He was then living in the state of Washington in 2015. He was interviewed on video by the police out there in 2015 and confessed. And then this case was just in warrant status until he was picked up by the U.S.
I got, you know, don't have here in the file. Second. Copy of the felony information. I have the original complaint.
I have a copy of it.
Thank you. A different spot. Thank you. Okay. The original complaint.
I don't have one either, Your Honor.
It's also just somewhere lost in the system.
I have multiple extra copies. I apologize. I thought they were filed by the prosecutor's office here. I'm writing one to the defense.
This is the felony information.
Yes.
It appears accurate.
I got mine.
You have yours.
Yep. All right. I've got a copy. All right. Thank you. Oh, the sentence. Did anybody run a guideline to say, give me an idea?
It's the middle of the guideline range, Your Honor.
Do you know what the guideline range is? That's all. I just want to be able to talk about it with you.
I do, Your Honor. If you were to proceed to trial, it would be 57 to 95 months for each count, with the court's discretion to serve it consecutively.
So that, yeah, that equals out to 4.75 to 8 years. So 6 to 15.
Thank you. All right, Mr. Sutton, have you heard what the attorneys have said?
Yes, sir.
Is that how you wish to resolve today's file, sir?
Yes, sir.
All right, to the best that you can, and you may of course remain seated, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
Thank you. You may lower your hand. All right, Mr. Sutton, we're going to go over this plea agreement, and if you have any questions, just let me know. And we're also going to go over your rights. You are currently charged on a piece of paper called a felony information with 3 criminal offenses. Each offense is a charge of criminal sexual conduct in the 3rd degree on a person between the ages of 13 and 15 years of age. There are 4 different degrees of criminal sexual conduct, and criminal sexual conduct in the 3rd degree involves an act of penetration. Now, each one of these offenses would be a felony punishable by up to 15 years, plus there would be mandatory AIDS and STD testing required by law, plus DNA taken upon arrest, and there would be registration underneath the Sex Offender Registration Act. In this particular case, it would be a tier 3 registrable offense. How old was he in relationship to the person? I don't know what his age is now, so I can't figure that out, but was he more than 4 years of age is the key question.
Yes, sir.
Okay. All right, thank you.
She was 14. He was in his early to mid 20s, I believe.
All right, thank you. And so a tier 3 would be registrable for 25 years to life, correct? 1 second. Yes. And oh no, I'm sorry, strike that. It's your That would be required quarterly reporting, and it would be lifetime, sorry, thank you, I'm sorry, I was incorrect. And, oh, I forgot, is there lifetime electronic monitoring?
Not for this.
Not for this one, because it's, because it's, a
Over
three, not a,
50.
yeah,
Correct.
copy that. All right, now there also could be potential consecutive sentencing. Consecutive sentencing means that the sentences for each offense would run back to back, not at the same time, but would run in chronology. So for instance, if a person had 3 one-year sentences that ran consecutive, the person would serve 1 year, then 1 year, then 1 year, versus concurrent. There's an agreement here that this will run concurrent. Any sentence under 3 offenses. Now, I'm told today you're going to plead guilty to all 3 of these charges of criminal sexual conduct in the 3rd degree. And apparently they all involve the same alleged victim. They also allegedly occurred, looks like back on a date range of May 1st through July 30th of 2014 in the village of Man here in Wexford County. All right. Now, there's also a couple other terms to the agreement, and they're regarding sentencing. I said a couple, there's really just one. We're going to talk about that in just a minute. Now, by entering a plea of guilty, if this court accepts that plea, you're not going to have a trial of any kind, and you're going to be waiving certain rights that you would otherwise have at a trial. Now, Mr. Cherry has handed to me a form that at the top says advice of rights, and at the bottom it appears to have today's date and your signature. Again, is this your signature?
Yes, sir.
And did you read through these rights before signing?
Yes, sir.
Did you understand what you read?
Yes, sir.
And again, do you understand that if you plead guilty and I accept that plea, that you will be waiving those rights?
Yes, sir.
All right. Now, if I accept that plea, you will also be waiving the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or the plea was not of your own free choice. Has there been any other threats, promises, coercion, duress put upon you to enter a plea of guilty today, other than what we've talked about?
I believe so, sir.
You do?
Yes, sir.
Okay, tell me about that.
From this paper, it was sign this plea or she was gonna add more charges, sir.
Okay, oh, that reminds me, there's something else I need to talk about. Thank you. We're gonna cover that. I forgot that. The other agreement or term is that prosecutor agrees not to bring other criminal charges based upon whatever it was that you said to the law enforcement officers that was what we call inculpatory, or basically a confession of other acts. Now, what I've been told by the council is that those other alleged confessed acts would be to another criminal offense of criminal sexual conduct in the 2nd degree.
No, sir.
I'm sorry?
4th degree.
4th degree? I thought there.
She had said second.
All right.
I didn't.
It's okay.
I believe they'd be 4.
Yeah.
I think they would be 4.
Thank you. 4th degree criminal sexual conduct is a high court misdemeanor punishable by up to 2 years and or $2,000. Plus, there's also additional. There could be sex offender registration, but of course, that's already required in the other offenses. When you look at sexual conduct in the 1st and 3rd, they involve acts of sexual penetration. When you look at counts 2 and 4, those are acts of sexual contact, like touching. Anywhere, the best description would be anywhere that's covered by underwear or bikini or swimsuit. So I'm told that they are agreeing not to bring any other additional charges. Now, thank you for covering that. And so before I turn to you and ask if there's anything else, let's go ahead and cover the sentence portion. Now, the attorneys have told me about what's called a kilobrew agreement. They didn't use that phrase, but they know I don't do the other types of sentence agreements called Cobb's agreements. A Cobb agreement, and the word Cobb is just an appellate, it's the name of a defendant from another prior appellate case. And a Cobb's agreement is where the parties and the court agree to the sentence at the time of the entrance of the plea. I don't do this. Why? Like in this case, the victim has a right to be heard, and I haven't heard from the victim. And I don't know anything about you, which you must not live in the local area, because most people that come in here I see a lot. So I don't do those, but what I do are killer agreements, and that is if at the time of sentencing that I do not go along with the pretrial agreement, then you would have the right to withdraw your plea and come back to this stage of the proceedings. Now, you've heard us talk a little bit about these things called the Michigan Sentencing Guidelines. They are not mandatory. They are a tool used by the courts, given to us by the legislature to help us find and establish a proportional and reasonable sentence. Now, the attorneys have told me that they have agreed that the estimated range, and that's a key word, estimated, is somewhere between 57 and 95 months, which is roughly 4 3/4 of a year to 8 years. And they have agreed that, and so far you've agreed to it, we haven't entered that plea, that the sentence will be for 6 to 15 years. So it's pretty much right in the middle, a little bit, basically right in the middle. So the point here is if I don't go along with that, which I have no reason to think that I won't, but I don't make a promise, you would have the right to withdraw your plea. Now I need to go back and answer that question. Were there any other promises, threats, or coercion or duress to get you to plead guilty that we haven't talked about?
No.
Great. All right. All right. Do you still wish to enter the plea today?
Yes.
And are you entering this plea of your own free will?
Yes.
Before we get to the plea, do you have any questions about your rights that we've gone over?
No, sir.
Do you have any questions about the pretrial agreement and the plea that you're about to enter?
No.
Do you have any questions about the potential sentence that could be imposed? So as to counts 1, 2, and 3 on the felony information, each of them being a criminal offense of criminal sexual conduct in the 3rd degree, how do you plead?
Guilty.
Before I can accept that plea as to those 3 allegations, the 3 counts, I need to have you tell me what you did that makes you guilty of that offense. Turning your attention back to the state range of May 1st and July 30th in 2014 up in the village of Manton here in Wexford County. What happened? Let's talk about the person. I don't want you to use that person's name, but can you just, or full name, but can you just give me a first name? All right, and how old was that person at the time?
Just shy of 14.
Okay, and did you know her or have any relationship with her?
Not really.
No. And so tell me what happened. How did these acts occur? Where do they occur?
I was visiting family, and she was living with one of my family members.
Okay.
And then I didn't know her that well, but we were sitting up one night, and then she gave me oral while I fingered both of her holster.
All right. So we're going to talk a little bit about that. And what you just said here isn't anything wrong. And the law requires me to ask for specific facts to fit specific words in the statute. What you described, very common, by the way. All right. So now at this time, you said that she was under the age of 14, but somewhere between, so basically she was 13, correct?
That's why I come to understand, yes, sir.
All right. And how old were you at the time?
I believe I was 22.
Okay. And where did the events occur? In a car, in a house?
In a house.
Okay. And it was in Manton?
Yes.
And in the house, was it like in a bedroom, in a living room? Tell me a little bit about
Living
it.
room.
Okay. And these occur all in one day, one event?
Yes.
Okay. And I'm going to ask this question. One day, well, one day, 24 hours. Was it all one encounter between you and?
One encounter.
All right.
All one time.
Okay. Now, you said you used the words, she gave me oral. Now, I have to fill in some gaps here. By that, do you mean that she placed your penis into her mouth?
Yes.
Okay. And it doesn't require any proof of ejaculation, so I can stop there. Now, you mentioned, and you used the phrase, you fingered both holes. We might be able to figure out what that means, but I need to ask you, did you place your digits, in other words, your fingers into her vagina?
Yes.
And did you also place your fingers into her anus?
Yes.
Okay. And all three of these acts were to for some sexual purpose, is that correct?
Yes.
Okay. Ms. House, do you think the defendants provided a factual basis to support the plea as to those three counts?
I do, Your Honor. Thank you.
Mr. Cherry?
Yes, Your Honor.
Ms. Carrot, I'm sorry. Ms. House, are you aware of any other promises, threats, or inducements?
I am not.
Sir?
No, Your Honor.
And Ms. House, do you believe that the court's complied with Bishop Rule 6.302?
I do, Your Honor. Thank you.
Mr. Cherry?
I do, Your Honor.
All right, thank you. I'm out of an extra ounce of precaution here, Mr. Sutton. When I asked you this question about how old she was, you said you came to find out. Did you have any doubt that she was underage at the time these acts occurred?
No, I just didn't know she was that young.
Okay, so you knew that she was at least under the age of 16, is that correct?
Yes.
All right, good enough, thank you. The court hereby finds the defendant's pleas have been made freely, knowingly, and voluntarily, and the court further finds that the testimony provided by the defendant under oath on the record satisfies the elements. Therefore, the defendant is found guilty of counts 1, 2, and 3. All right, Mr. Sutton, the case will be set for sentencing. Between now and then, which will be in about 5 weeks, agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. Now, one of these reports must be prepared anytime someone's convicted of a felony in any state court here in Michigan. That report will include a description of the offense, a description of the pretrial agreement, any statement or information you make or provide while in the preparation of this report, as well as a detailed history about you, detailed criminal history if you have any. That will also include a score in the Michigan sentencing guidelines, and it will make a recommendation as a sentence. Now, all of this is really important. Remember, the guidelines are not mandatory. Whatever the recommendation is not mandatory. Even the agreement that you reach with the attorney is not mandatory upon me. I get to make my own opinion or make my own decision based within the court's discretion. Doesn't mean, however, that I won't basically go along with the agreement. I think both counsel can tell you, Judge Elmore generally sits somewhere right in the middle of the guidelines for a lot of reasons. It encourages people to know what the judge is likely to do, and also hopefully eliminate some appellate issues. But anyways, all right, so there are 3 steps that involve you with the preparation of this report. Number 1, the clerk is going to give to the corrections officer a manila folder. They'll give it to you there at the jail. You're going to open it up, follow the instructions, fill it out. Be as complete and accurate as you can. Then you'll be subject to an interview with an agent from that office. You have the right to have Mr. Cherry present during that interview. And last, Mr. Cherry will come and meet with you generally about 2 weeks before we come back to court. And the 2 of you will go over that report. It's important that you go over it together because each side has the right to come back to this court and make objections or request corrections, because sometimes the information in there might be incorrect. Have any questions, sir, about what we have done today?
Okay.
All right, thank you. The court hereby revokes bond and remands the defendant to the custody of the Wexford County Jail. Why that might be academic, we've covered it for the record. Anything further, Mr. Cherry?
No, Your Honor.
And Ms. House?
No, Your Honor. Thank you.
All right, thank you. Ms. House, I know because you're covering for the local prosecutor's office, just as a reminder, only because you had this little hiccup today with the information, make sure they contact the victim and we don't have any issues with the Victims' Rights Act.
Yeah, and just for the record on that, the victim is watching on YouTube today. I have met with her multiple times in person.
All right.
She supports this plea and sentence agreement, and I believe that she will be present and make a statement at the time of sentencing. She just wasn't able to be here in person today.
No problem. That's always a big thing to the court. Is not that the victim has to, anyone has to go along with it, but their input's important. Anything else, sir?
No, Your Honor.
All right, Mr. Sutton, we'll see you in about 5 weeks. Thank you. We're adjourned.
Okay, so I just heard at the end where he said we'll see you in about 5 weeks, but did anybody catch if there was a sentencing date that was announced? If there was, let me know and I'll make a note of it. Otherwise, I can play it back later and try to figure it out. But if you caught it, let me know. Let's change it up. Let's go to Jefferson County Court at Law number 2 and say good morning to Judge Rubber Gloves.
On the
Oh, on the
UCW.
UCW? Yeah, I can get that.
Yeah, it's gonna be dismissed as part of forfeiture. He's already gave you your.
You already have the forfeiture?
Yeah,
It must be
yeah.
right there.
It might be low.
That's it.
Yeah, it's right there.
Okay, Jefferson County Court at Law number 2 is in session. The court is in session in 2 cases. Cause numbers 24 CCCR 2922 and cause number 24 CCCR 2924. Both cases are styled the state of Texas versus Zachary Allen Purser. Mr. Purser, is that your full name?
Yes, sir.
Purser, would you please raise your right hand? Mr. Purser, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Purser, you may put your hand down. How are you doing, Mr. Purser?
Good. How are you, Judge?
Well, fine. Thanks for asking. Mr. Purser, your attorney in these cases is Jason Nix. Mr. Nix is not here today. However, standing in for Attorney Nix is Attorney John West. Does Mr. West have your permission to stand in for Mr. Nix?
Yes, sir.
And Mr. West, how are you doing?
Great, Your Honor. Thank you. How are you this morning?
I'm doing fine. Thanks for asking,
Hey, it's
Mr.
Friday.
West.
It's good.
Oh, yeah, it is Friday. Yeah. Now, Mr. West, do you waive a record in Mr. Purser's case?
We do, Your Honor.
The state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor.
That's good. Now, Mr. West,
Yes, Your Honor.
in cause number 24 CCCR 2922, I have before me a document that is titled Information. In this information, Mr. Purser, it alleges that you, Zachary Allen Purser, on or about June 18th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Purser, this information further alleges that prior to the commission of this offense on August 5th of 2005, in cause number M245673 in County Court at Law number 3 of Jefferson County, Texas, that you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Mr. Purser, is that true?
Yes, sir.
Now, to this Class A misdemeanor offense of driving while intoxicated. Second, how do you plead guilty, not guilty, or no contest?
Yes.
Guilty. Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Purser, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, ZAP, that are on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Sir.
Mr. Person, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that Mr. West went over?
Yes.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? Mr. Purser, are you a citizen of the United States?
Yes, sir.
State Office States Exhibit 1, Your Honor.
Any objections?
No objection.
No objection. States Exhibit number 1 will be admitted. Mr. West, you have advised and counseled Mr. Purser. Is there any evidence that he is currently mentally incompetent to stand trial?
I cannot, I did not see anything this morning, and Mr. Nix has informed me that he is completely competent.
Okay. And Mr. Purser, your attorney, Mr. West, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir. I would say, let's say that Mr. Nix, because he's been advised.
Yeah, well, I'm saying you.
But today.
Yeah, I was
yes.
getting to that.
Okay, good, good.
And Mr. Nix has also advised and counseled you.
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay. Mr. Purser, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we would ask for 180 days county jail, probated for a period of 18 months of community supervision with a fine of $750, 80 hours of community service, and the standard DWI second terms and conditions with the interlock device and the 72 hours of jail time, as well as repayment of court costs. And then in exchange for the plea to the DWI second, Your Honor, the state agrees to dismiss the companion case, cause number 24CCCR 2924, with the forfeiture of the weapon that was involved in that.
When is it your time to begin?
Your Honor. And also on that, Your Honor, he would like to be able to just drive over to the jail, turn himself in, and get the jail time started this morning, so that way he can be out Monday morning.
Okay.
We go by.
Okay, now, Mr. Purser,
Yes, sir.
the state is offering that you serve 180 days in the Jefferson County Jail. This 180 days will be probated for a period of 18 months. During the 18-month probationary period, you will be required to pay a fine, $750, court costs $392, a DWI conviction fine fee of $100, probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to pay Jefferson County Court DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $137 a month. Will you be able to pay the $137 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service, install an interlock device on any vehicle that you own or operate, attend a completely DW education class, have an alcohol assessment, serve 72 hours in the Jefferson County Jail starting today at or before 6 p.m. You'll be required to adhere to the other standard terms and conditions of this probation. And as part of this plea bargain, the state will be dismissing cause number 24CCCR 2924 for forfeiture of the weapon, in that case, to the Port Neches Police Department. And I have before me a document that is titled Motion to Forfeit. Mr. Purser, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Purser, before you sign and initial this before you sign this document, did Mr. West go over this document with you?
Yes, sir.
And do you understand everything that Mr. West went over? Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Purser, I'll be granting the order to forfeit the weapon in this case to the Port Neches Police Department. Mr. Purser, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Purser, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Purser, you're gonna stand at the end of that table, follow the direction of the bailiff. Once you finish following the directions of the bailiff, you'll be able to get a copy of the judgment and a copy of the dismissal. And once you get that, you're free to go and you have a blessed day. And Mr. West, you're free to go as well and you have a blessed day. Did you sign that dismissal?
You still gotta go over there, you know that.
Alrighty, let's stay in the same building, but we'll switch courtrooms. Judge John Stevens.
BINE, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You were here with your attorney, Mr. Kimler, and the state's attorney. And your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation that was filed on April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that first amended includes that new indictment. Maybe let's see. Yeah, allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state's, she's gonna plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that out.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking
Or we'd ask the court to revisit the issue of bond. I know her mother is desperate to have Lloyd's. Probably been much into professional.
All right, I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this court's Exhibit 1, today's date. 6/6/25. It is made a part of the record for all purposes, and we'll keep this in a sealed form. Objection to its
Without objection. No.
Right, is made a part of the record for this case. The defendant, this motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8. It is alleged that on March 19th, 2024, which would have been about a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person also on that date. And the defendant is on deferred or unadjudicated probation for the 3rd-degree felony of injury to a child or disabled person or elderly person, and it would be what? No, talking about which of those? Elderly person.
Yeah, yes, that's her mother.
Okay. So when can we have this hearing? As soon as possible.
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. 17th or 18th, y'all pick.
What day?
Today's 6th.
This 17th, I'd say.
That's gonna be week after next.
So Friday or Thursday?
It's a Wednesday. It's like a Wednesday or
Tuesday and Wednesday.
Wednesday or Wednesday. All right, it's set for Wednesday, 17th? 18th. Okay, here is the order on the finding on Rapon. Dr. Rapon, that needs to be placed in the seal envelope. And also 24CR, the new 530, the new indictment on harassment of a public servant, that will roll with the motion to revoke probation. Shelby Solorendi. So it says there's gonna be a plea.
Well, that's not a plea. I'm trying to get the boss for her to go to rehab. So, yeah, I think at this point, the plea would be premature. I'd like her to try to get some rehab under her belt before I dispose of it.
Well, you know, they have, we do that.
It's not.
That's a term of probation.
It's not a probation law. The state hasn't offered probation.
The state has offered probation. Senator Tim with a mandatory jail of 10 days and a $500 fine.
I'm discussing.
Yeah.
They've offered you probation.
Yeah, y'all talk about it outside the presence of 250,000 people. Sorry. Arlie Weaver. Hey, Ryan. You've got Arlie Weaver, 3 cases.
That's Miss Staub, is it not?
Huh?
That's Miss Staub, isn't it?
Well, Arlie is missed up?
No, that's her case. I'm sorry. Her case is.
It says 3 cases. It says 3 cases defendant to plea.
Yeah, well, I mean, it's an NTRP.
Is that what she's gonna do? I don't see it. There's nothing on the pad.
Just we could plead administrative.
Is that what you're gonna do?
I have an updated PSA. It is when she gets out, I'll kind of explain the situation. This is Miss Weaver again.
Let's see. We got 1, 2. She's on 3 probation.
Yes.
Correct, Your Honor.
Okay. I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed.
Correct, Your Honor.
First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Cause numbers 23CR 2129, 24CR 37, and 24CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does with Mayor.
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Well, there's some similarity here on 23CR 2129 and 24CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24CR 37. Are those allegations true and correct as they are alleged now?
Yes, sir.
There you got 8 violations. Where are we proceeding on? Did y'all talk about?
We haven't touched, I would just go through the she can have please and true and not true.
Yeah.
That's
To what?
Well, if you would just rate someone out there and she can be not please.
Okay. She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3, because we held it in abeyance in October of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these offenses for probation. Okay. All right, so let's take them up. New 1. States you failed to report to the Jefferson County Probation Office for the months of April, May, June, and July of 2024. And that is similarly alleged in each of these 2 cases, 23 CR 2129 and 24 CR 37. And that was in violation of your probation order. Is that allegation true and correct in each of these cases? Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged? You understand that a violation proven by a preponderance of the evidence or greater of 1 or more violations of probation, that is enough to grant the motions to revoke probation. Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which sure on site. Which are state jail felonies, not enhanced. So you're looking at, in each of these 2 cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Stand by. Happen to these new substantive offenses, and looks like it's numbers 4 and 5. Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
Is that the Orange County?
It didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County offense.
It is Jefferson County.
The assault was refused from our office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these 2 cases. Is that allegation true? Completely true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024, you were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true? And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification of performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Sure.
Yeah.
Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor,
No?
it is to back to
Go
the
ahead.
court. She was bench warranted over here from Orange County. Judge Parkhurst in the 260th court has sentenced her to probation and ISF on the
Burglary of habitation.
It wasn't new.
Okay, was it older?
Time that all these crimes are committed.
There was an older burglary of a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what it's been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to get with the 260th of Judge Parkhurst to see how he's going to proceed on that.
How many children do you have
One.
already?
Yes, sir.
This will be your second?
Yes, sir.
How old is your other child?
7.
Ma'am?
7.
So I don't think that ISF or SAP is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court can be aware of what her current situation is and how she's on obstacles that she's had while on probation before you determine whether
on these cases. Is there any restitution?
No, Your Honor.
No.
I'm not that I believe.
Either.
I don't believe so.
I think that I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes, sir.
Have you spoken to Franklin House or have you?
Yeah. Yes, sir. I was there the day before I went to court in Orange County, and I've been in jail since then.
So you put yourself into rehab?
Yes.
I'm sorry, Your Honor. She has $250 restitution in 2129.
You able to pay that?
I would think her family would be able to pay that, Your Honor. I'll represent to the court.
When?
They hear anybody?
Here.
Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other restitutions.
There's another restitution, the cost number 2001. The amount of $3,200.43. So she has 3 cases.
I understand. 2. Yeah, 2. The first 2 were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes.
of 2024.
The total restitution is 30,000. Who's the 3,000? Who is that now?
It's not written in that order. So I don't know. I don't have the old case with me.
To reset it for sentencing. See what.
No, let's see what she has in accrued time right now. And I've got.
Well, I know the court's out of that restitution.
I know. And they're going to, her family can pay that first restitution what I want to do is dispose of these two
I see.
and then keep her on.
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, so she was in other places, but our warrants weren't.
She's got 165. So you see, you see what I'm going to do.
Yes, I understand.
All right. But the restitution has to be paid or I'm going to undo it by the end of the day.
Up to 250.
Yeah, the 250.
250.
Yeah.
Hang-
Yeah, he's going to tell you how to do it. Yes, ma'am. And we'll help you navigate through this so it can get done. Because the court has a plan here to try to whittle down these problems. Okay. All right. Anything else to add?
No.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these two cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently to allegations 1 and 2 of the motions failing to report and failing to provide verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these two cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those two cases based upon these violations of probation. And you are hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah, you go to the probation office, which is not far, you know, a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in 24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in this state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is you got to report or else you're not on probation. You have to pay the restitution back. Quicker you pay the restitution back, get you out there, get you to get an income, be responsible, fixing your messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best and the best you can be. Do you understand where we are on this?
Yes, sir.
Okay. So.
Yes, no, Daniel is. Yeah.
But that restitution is owed in an amount of $2,500. Did I say 2,000 or 3,000?
It's three, Your Honor.
$3,500. But you got to get that done before the end of probation. And the quicker you get it done, the quicker that's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes, ma'am. Okay. Everybody understand where we are on this?
Yes, sir.
Okay. Any questions, ma'am?
No,
All
sir.
right. Good luck to you.
Thank you.
Good luck.
But on
I know. Well, you had to take them in a
No, it's good.
installments then.
Okay, so what, about an hour and 20 minutes ago now, we were with Judge Simpson, and they asked for like 5 minutes, and he said, you asked for 5 minutes and you end up with hours. This is Judge Simpson's feed right now. They are still in recess over there, so don't say that he doesn't know the people who appear in front of him. He called it, and he called it perfectly. Let's head back up to Michigan and back up to Judge Elmore's court.
From the Misaki Community Corrections Program. And now, seated next to Mr. Hartel is the defendant. All right, we're here with a bond issue. So, we need to hear from Ms. Matsky.
Yes, Your Honor, people call Ms. Matsky.
Come on forward. You swear or affirm the information testimony about the provide shall be the truth, whole truth, and the truth.
Yes.
You may have a seat. Court takes traditional notice. This is Miss Alex Matsky from the Western Misaki Community Corrections Program. Go ahead, sir.
Thank you. Ms. Matsky, was your office supervising Mr. Foster's release to treatment back in April of 2024?
Yes, we were.
And on what date was he released from the jail to treatment?
He was released on April 18th of 2024.
And on what date was he released from treatment?
He left treatment on April 24th, 2024 against staff advice.
Okay. And what happened after April 24th, 2024?
Our office sent a violation in May, on May 10th of 2024, we were notified by the public defender's office that he did return to treatment on April 29th of 2024.
be able to verify that with the treatment center?
We did not verify that. They did verify when he left treatment again.
And on what date was that?
That was on May 12th of 2024.
And what's the name of this treatment center?
Meridian.
Okay. What happened after May 12th of 2024?
After May 12th, he should have come to our office to enroll in random testing. He did not do that. We did not have any contact from him, so we sent a violation to the court.
Okay. And have you had any contact with Mr. Foster at all after May 12th?
We have not.
Thank you. I have no further questions for you at this time. Oh, I'd ask the court to take judicial notice that Mr. Foster had testing conditions as part of his treatment.
I see all that here in the court's orders. Thank you, Mr. Hartel.
Yes, thank you. Ma'am, for the May 12th date, did you receive any notification my client completed the treatment before he was released from there?
If he completed prior to May 12th?
Either on May 12th or prior to it, if he completed before he left, the last time that he left.
He did complete successfully.
All right, thank you, ma'am. No further questions. Thank you.
All right. Thank you. One moment. I'm actually looking for the terms and conditions of the bond. Those must have been set. Looks like they were set by the district court.
I believe so, Your Honor. Yes, I have district court notes that he was released from treatment in that court.
All right, thank you. Ms. Maskey, you may retake your seat. Thank you. All right. Anything further, Mr. Carnes?
Your Honor, I'd ask the court to take judicial notice that the defendant failed to appear at his circuit court pretrial conference on June 7th, 2024, and was not heard from again until he was picked up. I think it's been a couple of weeks.
All right, thank you. Mr. Hartel, anything further?
Nothing further from the defense, Your Honor. Just so the court is aware, I have sidebarred with my client, and after this is completed, I believe he will be taking the people's offer after all. Thank you.
All right, thank you. The court hereby finds the defendant in violation of his bond based upon the information contained in the file, as well as the testimony by Ms. Maskey. Therefore, bond continues revoked and he's remanded to Washington County Jail. Thank you. Ms. Maskey, if you need to return, you may. All right, we're here next for the entrance of a plea. Mr. Carnes. What do we anticipate the plea to be?
Your Honor, if the court can give me a quick second, I apologize that
No worries. Second is always just a second.
should ask for a minute now, but
It's okay.
I will.
I'll note that at one time, I thought this was supposed to be a no contest plea, but there was no lab report.
Oh, I can supply a lab report here.
Is he pleading no contest?
He is, Your Honor.
Why?
Both due to a lack of recollection due to the amount of time and also the fact that my client did sustain a brain injury. I don't have all the medical documentation on me, but he's been very forthright with me that it has impacted his ability to recall events, Your Honor.
Okay. Mr. Carnes.
Thank you, Your Honor. May I approach with people's proposed exhibit 2?
Sure. So the notes that I have is that the defendant is pleading guilty. Oh, thank you, Graham. Hold on, I need. Here's 1. And here's 2. Speaking to the court report, handing her to the exhibits. He was posting them and marking them with the stickers. All right, the plea here, as I understood it, according to the written pretrial agreement she handed the court, is that the defendant will be pleading It said guilty, but we're gonna mark no contest to count 1, possession of meth, and the people will dismiss count 2, tampering with evidence in the habitual offender 4.
Yes, Your Honor, that is correct. Additionally, there has been one additional promise made, and that is if the court accepts this plea, the defendant would be allowed to plead guilty to use in a pending case in district court.
Is that correct, Mr. Hartel?
All of it is, Your Honor.
What you wish to do, Mr. Foster? Please raise your right hand. Swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth. And lawyer hand. All right, Mr. Foster, I remind you to make sure that everything we talk about today is the truth, and I will treat it as the truth. All right, turning your attention back to September 8th of 2023. Were you on probation or parole at the time?
No.
Were you on bond and in any felony charges at the time?
No.
Where were you living at the time?
3137 North 23rd Road, Mesa, Michigan.
Is that where you still reside?
This is
Okay. And with whom do you reside there now?
my fiance, Sierra Taylor.
And were you still with Miss Taylor at the time?
Yes, sir.
When was your, looks, I know because we have this 4th habitual enhancement on here. When was your last felony convictions? Looks like they were all bunched up together.
Yeah, I would like to say 2018, maybe 2015.
All right. And what were they for? Do you recall?
Delivery manufacturer, I believe.
All right. Is there a delivery and manufacturer in the defendant's prior criminal history, Mr. Crunch? You're looking for that. Mr. Foster, do you have a job?
Yes, I do have a job.
And where you been working since?
I am a tattooist. I work for Perfect Tattoos.
Okay. And how long you been working there?
Since 2022.
Your Honor, I see operating a laboratory and maintaining a drug house in 2018.
Okay. I also see some other ones here involving, looks like checks maybe?
Yeah.
What was that about, Mr. Foster?
And checks right there, I guess.
Yes, I don't know. And some larceny case. Do you remember what's that about? You don't know?
I don't remember right offhand exactly what case you're talking about.
All right, well, you're charged here today with a charge with 2 counts. Possession of methamphetamine, which is a felony punishable by up to 10 years and or $15,000. There's also a 4th habitual felony enhancement that could increase that maximum from up to 10 years up to life. Count 2 is an alleged tampering with evidence. That's a high court misdemeanor punishable by up to 2 years and or $1,000. And the court could, doesn't mean it would, but it could sentence the defendant consecutively, meaning any sentence for count 1 would run consecutive to any sentence for count 2. Moreover, because of the 4th habitual felony enhancement, that offense could be increased from a maximum punishment of up to 2 years to up to 15. However, if the defendant enters a plea to count 1 and the court accepts that plea, counts 2 and the 4th habitual enhancement will be dismissed. Now, Mr. Foster, there's another agreement out there that says, and that's part of this, it says, if this court accepts that plea today, they're going to dismiss you may plead to a charge must be charged with possession down in district
Charge of possession down in district
of meth,
of meth, yes.
that you're gonna plead to a use down there. Is that all right? All right, now I'm gonna cut right to the chase. I can only accept a no contest plea in a couple instances. One of them is because of potential civil liability. Well, that doesn't apply. And the other is lack of memory. The allegation here was not even from 2 years ago. Hold a job, you lived in the same place, you lived with the same person, you had a prior criminal history, you remember some of the offenses, but now you're gonna tell, and by the way, presuming, at least for today's purposes, you are using methamphetamine, the same substance that you're charged with possessing. I don't buy it.
About what, sir?
You don't remember.
I had on September 11th, 2024, I fell off a cliff.
Okay.
I have medical documentation. I don't have it with me. I have a head injury. I fell 18 feet onto concrete. I broke my shoulder blade, back of my skull.
Okay. All right, Mr. Hartel, do you have any objection to that?
I have no objection, Your Honor. I've talked to my client at length about it.
Well, if you enter a no contest plea, it has the same impact as a guilty plea. The only difference is instead of requiring you to recite a factual basis to form the basis for the conviction, I'm going to look at something else like a police report, which you cannot challenge any of the details that are contained inside that report. Now, by entering a plea of no contest, if the court accepts that plea, you'll not have a trial of any kind. Does that make sense? Enter a plea of no contest, you'll be waiving certain rights. One moment. Mr. Hartel has handed to me a piece of paper that at the top says advice of rights, and I'm showing it to you now. At the bottom, it has what appears to be your signature. Is that your signature?
So
Did you read through these rights?
I did my best I could.
Let's go over them now. If your plea is accepted, you will be given the right to be tried by a jury, the right to be tried without a jury. If you chose and the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond reasonable doubt that you are guilty, the right to have the witnesses against you to appear at the trial, the right to remain silent during the trial, the right to question those witnesses against you, the right to not have unsolicited used against you, the right to have the court order any witnesses you may have for defense to appear at the trial, and the right to testify at the trial if you chose to testify. Do you understand those rights? And do you understand that by pleading guilty, by pleading no contest, if this court accepts that plea, you will be waiving those rights. Additionally, if your plea is accepted, you will be given a right to claim that the plea was a result of any promise, threat, or inducement not told to the court today on the record, or the plea was not of your own free choice. Are you mentioning the plea of your own free choice?
My original understanding of the plea is that I would most likely get county time. I would have accepted.
We're going to talk about that in just a moment. Last, we'll talk about it right now. All right, there is no agreement as to the sentence. Am I correct?
Right, Your Honor.
Mr. Hartel
That
said
is correct. I went over the scoring guidelines, but there's no agreement.
copy. Now, Mr. Hartel, as a defense attorney, is supposed to talk to you about potential sentencing to try to give you an idea as to what he thinks the court may sentence you to. Now, he probably has talked about the Michigan sentencing guidelines. Those are not mandatory on the court. And he doesn't, when they score them, the attorneys are doing the best they can based upon figuring them out. They have training, they know how to do it, but sometimes they might be wrong. That's why Mr. Hartel just used the word estimate. So if you understand that whatever he's told you or try to help you get an idea of is not a promise. All right, and you understand it's me, the judge, who sets the sentence, correct? All right, and I have absolute discretion in doing so. All right. Now, have there been any other promises, threats, inducements? Okay, and are you electing to enter the plea as we discussed? As to count one, how do you plead? Before the court can accept the plea, the court needs to look at a couple exhibits. The court has been handed, as we discussed already on the record, 2 exhibits, People's Exhibit number 1 and People's Exhibit number 2. Number 1 is a incident report from the Wexford County Sheriff Department, and it's got an incident report number of 83-2301902, and it consists of an initial report and a series of supplements. Mr. Carnes, are you asking the court to accept it?
Yes, Your Honor.
Mr. Hartel?
As do we, Your Honor.
All right, People's 1 is hereby admitted. People's 2 is a Michigan State Police Forensic Science Division report signed by Karen Brooks, a forensic scientist at that office, with whom the court is familiar and has accepted as an expert in this court several times. I will note that at the top, it has an agency number, which has the same incident report that I discussed from People's Exhibit 1. And it, of course, has the defendant's name on it. Yep, there we go. You're asking the court to accept it?
Yes, Your Honor.
Mr. Hartel, any objection?
None, Your Honor.
People's 2 is hereby admitted. Mr. Hartel, I'm sorry, Mr. Carnes, please provide a factual basis to support the conviction.
Yes, Your Honor.
Mr. Hartel?
As do I.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
No, Your Honor.
Mr. Carnes, do you believe this applies to Rule 6.302?
Yes, Your Honor.
Yes, Your Honor.
The court agrees and finds the defendant's plea today is made freely, knowingly, voluntarily. The court finds that under the interests of justice do not require the defendant to recite a factual basis based upon the agreed upon impact of a traumatic brain injury. The court also has reviewed these items as they were provided to the court prior to taking of the plea, and the court is confident that they contain information satisfactory to accept the plea. Therefore, the defendant is found guilty of count 1 and count 2, and the habitual enhancement will be dismissed at the time of sentencing. Sentencing will be set in about 2 weeks. That will look, about 6 weeks. Between now and then, an agent of the Michigan Department of Corrections must prepare a pre-sentence investigation report. One of these reports must be prepared anytime someone's convicted of a felony in a state court here in Michigan. That report will describe the offense, the pretrial agreement, statements made by the defendant, and will include a score in the Michigan sentencing guidelines and make a recommendation as to the sentence. Keep in mind, it is merely a recommendation, and again, as it is the court alone that makes the determination of the sentence. Mr. Foster, there are 3 steps that involve you in the preparation of the report. Number 1, you're going to get a packet provided to you through the corrections officers that the clerk has just handed to the officer, and you're going to complete it, turn it in. Number 2, you're going to be subject to an interview with an agent from that office. Number 3, Mr. Hartel will meet and go over that report with you prior to coming back to court. Do you have any questions? Anything further?
No, Your Honor.
Anything further?
No, Your Honor.
Court can again revoke bond and remand the defendant to custody of the Wexford County Jail. All right, we are adjourned.
Okay, it's very important to me because it's Friday that none of you get any work done. So we're going to go ahead and go just a little bit long today. We'll go back to Judge Stevens and we'll watch at least one more contestant.
And Daniel Raleigh.
That's the state's motion, Judge. It has something to do with
Okay.
the state's regular.
Okay.
Judge.
And here is Chelsea Shipp. Does she need to be sworn in? All right, 22-40128 is called the State of Texas versus Chelsea Ann Marie Shipp.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here? This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here now?
Yes, sir.
And it, so
Is it because of the writing? Judge?
yeah,
It's 40 years, Judge.
okay. I'm gonna redo that, Jim. I know. I wish we had this pen for everybody. This pen seems to work better on the pad
Yes,
than
sir.
others.
Thank you.
And
Thank you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years in prison. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. Stand up. How do you plead to this indictment, charging you with this first-degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. McNally, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Shipp, you are pleading guilty to this first-degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of State's Exhibit 1, and the court supports those representations with positive findings that are in the record that state those admissions. I hereby find you guilty beyond a reasonable doubt of this first-degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it?
No,
Is there any,
no, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, now?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Take Mr. Peterson, take Mr. Patterson's file too.
Shall we do one more contestant? Put a one in the chat if you want to stick around for one more. FYI, Judge Simpson just came back online, but whatever it is they're doing, it looks like it's going to take a while. So I'm not going to go there, but he called it almost a 2-hour delay for something they said would take 5 minutes. So good on him. He knows his court. All right, we'll hang around for one more contestant then. By the way, you know, I say this a lot, and I say it because I mean it. Thanks everybody so much for your support. I maintain, and I will continue to maintain, that the community we're building here is far superior from others in the LawTube community because we have good discussion, we're all very good people, and I'm enjoying every minute of it, so thanks so much. All right, let's hang tight. We're a few minutes in the Wayback Machine here, so if he doesn't pull somebody up in the next minute or two, I'll see if I need to fast forward a little, but let's hang tight. Yeah, give me just a minute. I'm gonna fast forward just half a tick. Get past delays. All right, here we go. Except for the fact that he's muted himself. Come on, Judge, I'm trying to give you a chance here. Let's try this one. Nope. Oh, this is funny. All right. One more try. This is the last contestant I have in the queue since we were in the Wayback Machine. Let's try this one.
In paragraph 1, that on or about January 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWI convictions. In 2014, out of County Court at Law number 3, you were convicted twice. And paragraphs 1 and 2 constitute the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. You would be fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days confinement in the county jail as a condition of probation. Do you understand what these The plan is, and is this your agreement that you've reached with the state?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those 2 prior DWIs in 2014, are those true and correct as they are alleged?
Yeah.
And are you pleading true and correct to this voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and passed.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've heard it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record without objection. And anything further, I'm going to follow this agreement. I will find then that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here, which supports your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You are placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation, normal and customary for DWI type cases. You must serve 10 days confinement in the county jail. When can you begin that? Immediately?
Yes, sir.
And probation officer will prepare the probation order.
Let her know they may not.
There will be other conditions, including completing a DWI intervention class. That's good. You must have, as you probably heard from the previous case, an interlock device in any motor vehicle you operate.
Yes.
That you have to blow in. It has to, you have to pass the test or else the ignition will not start the vehicle.
Yes, sir. I have one right now.
Okay, we'll follow those terms and begin your probation successfully, okay?
Thank you, sir.
Judge, you need to see it.
I have Kedron Perkins.
This is my problem.
Okay, that was fairly short, so we'll do a second one more. Why not? It's Friday.
Is he going to be here?
I haven't seen Mr. Adams.
There. He's been all over.
Oh, no, that wasn't Langston.
I have Denise Madrid.
She's here, Judge. Let's get the review on testimony and all.
Okay, so we'll take her next after this.
You not have that?
I don't have.
Okay, I wasn't sure. To be sure what was happening today.
At the conclusion of these pleas, there will be one allocution, Judge.
Oh, these were add-ons?
Yes, sir.
Okay.
These are-
I didn't
Mr.
recognize his name.
Mr. Perkins is on Monday's trial docket.
Not anymore then.
Correct, Judge.
We're going to call 2 cases, cause numbers 22-39766 and 22-39767. The state of Texas versus, is it Cadrain or Cadron? How do you pronounce your first name? Kedron?
Yes, sir.
Perkins. And you are here with your attorney, Mr. Reynolds, and the state's attorney. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
He does, and you
You're
may.
pleading to both?
Yeah, that's correct, Judge. Same amount of time to run concurrent.
In summary, these two cases, and we'll take them up together because they are similarly alleging the first degree felonies of murder in each case. And these state in 39766 on or about January 30th, 2022. And in 22-39767 on or about January 1st, 2022, both alleging in Jefferson County, Texas, that you committed the first degree felonies of murder by shooting the complainants or the victims in each case with a deadly weapon, namely a firearm. There is a second allegation of a prior conviction of robbery. Are we using that?
No, there's no need, Judge.
Okay. Do you understand, sir, what you're charged with in each of these cases?
Yes, sir.
These are first degree felonies, which means you face a term of life imprisonment if convicted, or any term not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty in each case, found guilty in each case, sentenced to 55 years imprisonment to run concurrently with each case. Is that your understanding of the agreement?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Stand by, please. Show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily, knowingly, intelligently?
Yes, sir.
Did you discuss them with your attorney, and are the contents of these documents, State's Exhibit 1, all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each of these cases?
No objection.
Without objection, admitted. Among other things, these state that you are mentally competent to enter your guilty pleas. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, or you've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. We're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is all of that true and correct?
Yes, sir.
States Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports are waived.
So waived.
Anything else to add by either party? I'm going to follow these agreements.
Sorry, Mr. Thomas.
The only thing
Fine.
is,
You, in each of these cases, you are pleading guilty, sir, voluntarily, knowingly, intelligently to these allegations of the first degree felonies of murder in each case. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of these two first degree felonies of murder. I hereby find you guilty beyond a reasonable doubt of these first degree felonies of murders in each case. And I am following the agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 55 years on each case to run concurrently. There will be an affirmative finding in the judgments that a deadly weapon, namely a firearm, was used in the commission of these offenses. Do you understand, sir, what has happened today?
Yes, sir.
Anything else from the state? Is there anything?
We have an allocution from the victim's family on 39766, Judge.
All right. Go ahead.
Judge, he is in administrative segregation because he was contacting witnesses. And I think since that's no longer an issue, he's asking that the jail staff be allowed to determine where he stays instead of the court.
That's an accurate statement as to why he was moved into isolation. We had proven to the court that there were some threats against one of the witnesses that testified. Since we're not moving forward with a trial, I have no objections to the jail making administrative changes.
It is allowed, based upon no objection from the state. What do you have?
I have some family, Judge. I know where you want to situate.
Okay, the defendant can be seated right here in the witness chair. Thank you. All right, please, in each case, please identify yourself and how you are related to the victim in this case.
My name is Sabrina Matthews, Wagner Matthews. I'm Isaiah's oldest sister.
That's Isaiah Wagner.
Isaiah Wagner.
Who was the deceased, who was killed in this case.
Sister.
Okay, go ahead.
Sandra Matthews, the baby sister.
Okay. All right, you may go forward when you're ready. Thank you.
Isaiah Brandon Wagner, a gentle giant, was taken from us on January the 30th, 2022. Our parents' lives are not the same since that day. My mom is 84, 666 since that day. There's nothing we can do or say to her to make it any better. We wrap our arms around her and tell her I literally love her every day. Mama, it's going to be okay. Deep down inside, she doesn't think so. And she doesn't feel it. My dad is 84. Your parents and family and friends can go and visit you anytime they get ready. What we have to go and visit is a grave site of Isaiah. As one of Isaiah's oldest sisters, like I stated, we're a very close-knit family. All 5 of us. It was 3 boys and 2 girls. Our nieces and nephews, we're all like this. We come together in times of trouble and talk to each other and pray with each other, comfort each other, encourage each other. That's all we can do. He leaves behind 2 precious little children that between me and my sister and other family members help raise those children. Our husbands, they're here today to support us. They have helped in ways they didn't even ask for. But the love that they have for Isaiah's kids, that's what they do. That's what we all do. Jerry, my brother that's here today, you will always be our big brother, even though I'm the oldest. He's going to always be my big brother. It took us a long time, but not too long, to find out after Isaiah had passed, the grave site where the grass was growing at. It didn't take us that long to figure out it was him that was going out there cleaning that up. You took our loved one. I truly wake up some days in disbelief. I can't believe it. I touch it's real. He's gone. He's never coming back. I have a picture of him on my fireplace mantle. I pass by that fireplace mantle and I say, Isaiah, you don't even know what hit you that day. You hunted him down like an animal. For what reason? Oh, they said it was a girl. Oh, they said you disrespected me. How so? A human being. What happened to just talking? What happened to let's just get together? When I was growing up, it was just let's squash this. What happened to that? Take a life of another human and in that way. Coward. That's a coward. How could you? So disrespectful on so many levels. I feel mad. I feel angry. I'm sad for my parents, most of all. I can't even imagine. I have 3 girls. I can't even imagine them dying and getting killed, not dying just from a hospital stay or sickness. They had pneumonia and died. They had cancer and died. No. He was gunned down and shot and killed. Not one time. Kedron, not one time. You shot him 41 times on Grand Street. Get my numbers right here. You shot him 41 times on Grand Street. As if that wasn't enough, not 1 week later, 50 shots was fired, and then the gun was unloaded on him. You got 55 years for that. 55 years. He's gone. My parents are dead. They won't see it. If my mama makes it, probably with her help, and I'm not being funny. If she lasts another, I hope so, 10 years. The way her health is right now, God is my witness. I have no reason to lie. I'm sworn in here before oath. Who does that, I say? Who does something like that? But a person who just does not care for another human. Today, I found out how many times he was shot, 41 times. I said that. How are you able to look at yourself for what you did? You will never forget what you have done for the rest of your life. You have a long road ahead of you to think about what you've done. So I say all of this to say this. You are a soul that Jesus died for. I believe that. I believe in there's a place after this life. I believe in God. God died for you. He died for me. Yeah, Isaiah made some mistakes. I'm not going to get up here and paint a picture of Isaiah, that Isaiah was all that and a bag of chips. I'm not going to do that. Isaiah made some mistakes. So have I. So have you. So I say this. You are a soul that Jesus died for. You need to repent. I am a soul and a child of God that Jesus loves, and I need to forgive you. So, Kedron Perkins, I forgive you for what you did to my brother. May your soul rest in peace.
That's in church.
Hold on. Anything else? We are in recess. We are in recess on this case. Thank you.
Thank you.
Well, that's a very serious way to end our week, isn't it? And it's been that kind of week. It's been a lot of heavy stuff, huh? But you know, that is how the Courtroom Files works. We never know what we're gonna get. That's the beauty of this live show, I suppose. I'm glad we stuck around though to be able to hear from that, and good on her for offering forgiveness. I know that there'll be some people who agree or disagree with that, but ultimately, the idea of carrying around hatred will just eat you up inside. So hopefully it helps her live a better life. Bailey just said she has a big heart. I would agree with you, Bailey. But again, hopefully that helps her more than it helps him, because, like I said, just carrying around hatred just burns you up. So hopefully she can move forward in a positive way. Anyways, let's call it a week, my friends. I hope you have enjoyed it. I know I have. We'll be back Monday, of course, 10 a.m. Eastern, 7 a.m. Pacific, half an hour early for channel members. Again, if you're lurking around out there and you aren't a channel member, give it a try. Try it for just 1 month. It's a whole $2.99. And there's a link for that in the pinned chat. We do some fun things for channel members, but my favorite is the pre-show where we get together and just kind of talk and cover whatever we cover. Sometimes it's court, sometimes it's not, but it's a great little community, so I encourage you all to give it a shot. Yeah, go have yourselves a good weekend. Be safe, have fun, and we'll see you again Monday. Take care, as always, and God bless.